You might think the president can call an economic emergency and instantly slam tariffs on the world. But what if a single week at the Supreme Court gutted that power, rewired who can remove federal regulators, and narrowed scenarios where a president is immune from criminal prosecution? On the 9th of January 2026, Opinion Day produced a moment that could change how presidents use sanctions, run agencies, and face criminal accountability and markets. Agencies and Congress are still scrambling to respond. Stay with me. In the next 18 minutes, we'll break down the rulings, explain the legal mechanics, show what it means for trade, national security, and prosecutions, and map out the next legal moves you need to watch. Here's what this explainer will do. First, cut through the headlines and tell you what the court actually decided and what it didn't. Then we'll unpack the legal doctrines at play, IEEPA and the major questions doctrine, the removal power line from Humphrey's Executor and Seila law, and presidential immunity for official acts. I'll give concrete examples, dollar figures, timelines, and who's likely to sue next. Most importantly, I'll end with a clear timeline of practical next steps, stays, remedies, congressional fixes, and industry fallout. One quick note, this explainer is educational and not legal advice. If you need legal help, consult a licensed attorney. Let's start with the headline everyone's watching. Tariffs imposed under the International Emergency Economic Powers Act, or IEEPA. Why does that matter? Because IEEPA, a 1977 statute, gives the president broad authority to regulate commerce after declaring a national emergency affecting foreign threats. But does that include levying sweeping import duties and tariffs? That's the big question. Here's the background in plain terms. In early 2025, the administration began using emergency declarations to impose a series of tariffs and reciprocal duties that dramatically increased customs revenue. Treasury officials estimated roughly $30 billion a month in additional customs receipts during the peak. That's not pocket change. That's enough money that businesses, trading partners, and bond markets noticed. Lower courts, including the Court of International Trade and later the Federal Circuit, were skeptical. The Federal Circuit issued a decision on the 29th of August 2025 that limited or struck down the government's broad reading of IEEPA, which set up expedited Supreme Court review. Now, here's where it gets interesting. Major outlets reported intense expectation that the court might issue a definitive opinion on IEEPA, but live coverage on the 9th of January 2026 noted that the court had not yet issued a final ruling in that tariffs case on that day. So, we have to be precise. The litigation around tariffs is game-changing, but as of the live coverage on January 9, the precise status and text of a final Supreme Court opinion in that specific IEEPA tariff case needed verification from the court's official releases. So what would a ruling either way actually do? If the court narrows IEEPA, for example, by applying the so-called major questions doctrine and requiring a clear statement from Congress before allowing the president to impose duties that would severely constrain unilateral emergency economic actions, think refunds, rapid policy reversals, and a huge shift in bargaining power in trade diplomacy. If the court instead upholds broad IEEPA power, the executive branch gains a powerful rapid response tool for economic coercion. Either outcome changes the balance between Congress and the president on trade and sanctions. Up next, removal power. The court's tweaks there may make it easier for presidents to control independent agencies, but there's a twist you're not going to expect. To understand why the tariff case matters, we need to zoom into doctrine for a minute. The key legal tool judges use is statutory interpretation plus something called the major questions doctrine. The major questions doctrine says when a case involves decisions of vast economic and political significance, courts should require clear congressional authorization before letting an agency or president claim power. But what does clear mean? Historically, courts look for explicit language or unmistakable statutory text that Congress intended to delegate extraordinary authority. In recent years, courts have applied that doctrine more aggressively across different cases, not just trade, but environmental regulation, public health responses, and tech regulation. Here's where it gets complicated. IEEPA doesn't say the president can impose taxes or levy tariffs in explicit words. It authorizes measures that can regulate foreign trade and block transactions in response to national emergencies. The government's argument is that tariffs fall within arithmetic and regulatory measures that affect commerce, and so are within IEEPA's scope. Critics say levying duties is the kind of core taxing or regulatory power that Congress reserves for itself, unless it clearly says otherwise. That's the major questions battleground. To be concrete, lower courts questioned whether giving a single executive unilateral authority to impose across-the-board import duties created massive economic consequences that demand a congressional vote. If the Supreme Court adopts that skepticism, future administrations will face a higher bar before taking unilateral emergency economic action, and Congress will be asked to legislate precise emergency tariff authority. If the court limits IEEPA here, who actually pays the price? You might be surprised. Let's get practical. Treasury's rough estimate of $30 billion a month in extra customs revenue during the tariff period is a headline-grabbing number. If a court were to invalidate those tariffs, what happens to the money? That's where remedies and refunds come into play, and this is one of the messiest areas in litigation. Earlier reporting during the appellate process warned that, depending on the court's remedy, refunds could be substantial. Estimates floated in 2025 ranged wildly, from tens of billions to as much as $1 trillion in exposure if refunds were required broadly. Why the big range? It depends on how courts define the remedy window, statutes of limitation, whether importers can recover past payments, and whether Treasury uses administrative offsets or adjusts duties going forward. But here's the twist. Even beyond refunds, striking down broad IEEPA tariff authority would change bargaining leverage. If presidents can't impose immediate emergency tariffs, they lose a rapid, visible tool in negotiations with trading partners or adversaries. That could push more leverage to Congress, which has budgetary power and trade law tools like Section 301 and anti-dumping statutes, or to multilateral negotiations. Imagine global supply chains suddenly adjusting because a tariff program that once applied in real time is off the table. Businesses that hedged around tariffs suddenly face different input costs, and bond markets, which pay attention to fiscal and trade shocks, could recalibrate risk. This is why financial markets were watching the court's opinion day closely. Now, the tariff fight is only one strand. Removal of agency officials is a structural battle that decides who calls the shots at regulators. Shift gears, removal power. This is the question of whether the president may remove certain federal officials at will, or whether Congress can limit removal to protect multi-member independent agencies. Historically, Humphrey's Executor from 1935 upheld Congress's power to protect some officials from at-will removal when those officials perform quasi-legislative or quasi-judicial functions like members of the Federal Trade Commission. Fast forward to Seila law in 2020, where the court held that the president has the constitutional power to remove the head of an agency with executive functions, but allowed Congress to structure agencies with some protections in certain circumstances. The line between Humphreys and Seila law is where modern litigation lives. On the 9th of January 2026, term watchers were looking for a ruling that might refine or even reshape this line. Did the court narrow Humphrey's Executor and expand Seila law, making it easier for presidents to fire officials in a wider array of agencies? As of live reporting around January 9, major coverage did not identify a definitive new controlling removal power decision published that day. That uncertainty matters because even small doctrinal shifts here can transform agency independence. Why does that matter practically? If the court makes it harder for Congress to insulate agencies from presidential control, the president can change agency priorities through personnel moves, even without new legislation. Enforcement priorities at the FTC, SEC, FCC, and others could change rapidly.